Hey everyone, welcome to The Explainer. I'm so glad you're joining us today because we are going to take all that intimidating legal jargon right out of the dictionary and put it directly into a living, breathing timeline of how real court proceedings actually work. If you've ever felt totally lost watching courtroom dramas or reading dense legal news, well, you are definitely in the right place.
Let me ask you something. Do you actually know the exact difference between a plaint and a pleading? Or what the phrase beyond a reasonable doubt literally means when you're standing in front of a judge? Understanding this stuff, it isn't just for law students trying to pass the bar. It's absolutely crucial for navigating the justice system and, protecting your own rights.
Okay, let's dive into this. Here is our roadmap for today. 1. Civil versus criminal cases. 2. The civil lawsuit journey. 3. Inside a criminal trial. 4. The burden of proof. And 5. India's new legal era.
All right, Section 1, Civil versus Criminal Cases, the fork in the road.
Right off the bat, every legal dispute hits a fundamental fork in the road. Is it a civil matter or is it criminal? Civil cases are all about private disputes. This is usually between individuals or companies, where a plaintiff, that's the person formally filing the suit, is suing a defendant because they want compensation or some specific legal remedy. On the flip side, criminal cases, totally different ballgame. Here, the government itself is stepping in. A prosecutor is bringing charges against a defendant on behalf of the state because public laws were broken. They aren't just looking for a private financial payout, they want to enforce punishment, like jail time or fines. So it's really private dispute versus government prosecution. Moving on to Section 2, the civil lawsuit journey from dispute to decree. So how does a civil suit actually play out? Think of it like a really intense game of legal chess. Your opening move is the plaint. That's the formal document where the plaintiff lays out their exact grievance and what they want out of it. This forces the opponent to make their opening move, which we call the pleadings, where the defendant officially answers those claims. Once the paperwork is set, we head into discovery, and eventually the trial itself, where witnesses take the stand and the judge hands down a final decree.
I want to pause on that third step for a second, discovery. Before a trial actually starts, absolutely nobody wants a surprise. Those dramatic ambush tactics you see on TV, real-life judges literally hate them, and that's exactly why this mandatory pre-trial process exists. During discovery, both sides are legally required to share their information, documents, and evidence with each other so everyone knows exactly what's coming. Now, what's really interesting about this slide is one of the biggest tools they use during that discovery phase, the deposition. A deposition is a sworn, oral testimony taken completely outside of a courtroom, but it's recorded, either by a court reporter or on video for later use. It lets lawyers lock in exactly what a witness is going to say under oath, way before anyone ever steps foot in front of a judge or jury. And throughout this entire civil journey, attorneys aren't just sitting around waiting for a trial date. They are constantly filing motions. A motion is just a formal request, written or spoken, asking the judge to make a ruling on a procedural issue, decide what evidence is actually allowed, or maybe even throw the whole case out. It's how lawyers fiercely steer the ship day to day. But what if waiting for the end of a trial is just going to take way too long? Well, that's where an injunction comes into play. This is a super powerful, immediate remedy. A judge can issue an injunction to legally force someone to do or to stop doing a specific act right now. It effectively freezes the situation so no permanent, irreparable damage is done while the rest of the lawsuit is still being figured out. All right, shifting gears, Section 3, inside a criminal trial, the state versus the accused. The timeline for a criminal case looks completely different from the civil one. If we look at systems like India's, the whole journey typically kicks off the second a First Information Report, or FIR, is filed at a police station. That formal report triggers the police investigation, the forensics, the witness interviews. If they find enough evidence, the police hand a charge sheet to the court, detailing the exact crimes. If not, they file a closure report. But if that charge sheet drops, the stakes escalate instantly. The court formally frames the charges, and the trial is officially on. During all these investigations and the trials that follow, you're going to run into the word affidavit a lot. An affidavit is simply a sworn written statement made under oath. Witnesses or investigating cops will submit these documents to give the judge formal, verified facts without having to physically stand up and testify verbally for every single minor procedural step. Honestly, it's a massive efficiency tool. Now, the higher courts overseeing all this wield some massive authority, and they often use something called a writ.
A writ is basically a formal written command straight from the court that forces an individual, an organization, or even the government itself to perform or stop a specific act. It is the court literally flexing its constitutional muscle to make sure the law is followed.
And perhaps the most famous and vital writ of all? Definitely habeas corpus. It's Latin for "you have the body," and it's one of the oldest, most fundamental legal actions in existence. It empowers a citizen to challenge an unlawful detention. Think of it as the ultimate constitutional shield against arbitrary state power, demanding that the government actually justify exactly why they are keeping someone locked up behind bars.
Next up, Section 4, the burden of proof, the scales of justice. So the crucial point is that our legal system demands completely different levels of certainty depending on what's at stake. In a civil case, the standard is a preponderance of the evidence, meaning you basically just have to prove your claim is more likely than not to be true. If you're 51% sure, you win. But criminal cases, where someone's actual physical liberty or life is on the line, that standard shoots way up to beyond a reasonable doubt. The prosecution has to prove guilt to a near total certainty. You literally cannot lock someone in a prison cell based on a mere 51% probability. Which brings us to Section 5, India's new legal era, modernizing justice. Let's look at a massive real-world example of these procedures shifting. As of July 2024, the legal landscape in India went through a massive overhaul. 3 brand new criminal laws officially came into effect, replacing the old colonial-era codes. This new framework was built with a very clear focus, prioritizing speed, tech integration, and citizen rights over those archaic, paper-based processes. To put that into perspective, here is the translation matrix. The famous Indian Penal Code, or IPC, which defines the actual crimes, is replaced by the Bharatiya Nyaya Sanhita, or BNS. The Code of Criminal Procedure, the CRPC, which dictates the mechanics of how a case runs, is replaced by the BNSS. And finally, the old Indian Evidence Act is replaced by the BSCA, which governs what evidence is actually allowed in court. And this brilliantly illustrates how these upgrades actually impact the everyday citizen. Under the new BNSS, we see the legalization of the zero FIR. This means you can file a police report at literally any station, regardless of where the crime happened, which totally eliminates those frustrating jurisdictional delays. It also brings in EFIRs for online reporting, caps preliminary inquiries at 14 days, forces judgments within 45 days of a trial ending, and mandates 90-day progress updates for victims. The entire system is structurally being forced to move faster. Beyond just timelines, the system is fully embracing the digital age. These new laws mandate that trials, hearings, and even legal summons can be handled over audio-video screens. Plus, for serious crimes, anything carrying a punishment of 7 years or more, forensic investigations at the crime scene are now absolutely mandatory. They want hard, scientific backing for serious offenses now, instead of just relying on potentially faulty witness testimonies. So, what does this all mean? As our legal frameworks modernize and really embrace technology like e-files and digital evidence, how will these tools continue to reshape our everyday access to justice and fairness? It's pretty wild to think the legal journey is no longer just bound to physical paper and old courtrooms. Thanks so much for joining me to demystify all these processes today. Keep exploring, stay informed about your rights, and as always, stay curious.